so what is the role of Crown Counsel in BC? As I mentioned, police officers are not responsible for formally charging young persons or any person who's before the court. There's a particular designated Crown Counsel in BC that's responsible for charge screening. So they'll look through the circumstances of the offense. They'll look through what we call a will say. It's a police officer's formal notes about what they will say during court to give an indication to the Crown Counsel about the degree of evidence that the police officer has that this young person is guilty of the offense. Alternatively, maybe Crown Counsel believes that the young person is guilty, but that processing that person through the formal justice system is maybe not worthwhile because the offense is not particularly serious or because it's a young person's first crime. And so in this case, the Crown Counsel might elect to proceed through an extrajudicial sanction where the decision is handled outside the formal court process. It requires that the young person admit their guilt. And if they do admit their guilt, then they will go through the process of determining a sort of a penalty, which can include restitution or community service. And for example, a young person will be told that they have 6 months to complete 50 hours of community work service. And if they don't complete those hours of community service in the allotted time, then they can be charged for failing to comply with the conditions of their extrajudicial sanction. So they can actually receive a formal charge and a formal conviction. If they successfully complete their extrajudicial sanction, they will have no formal conviction on their criminal record. Judges also play an important role, but basically after Crown Counsel has elected to proceed with formal charges rather than an extrajudicial sanction. So for youth court judges, their main responsibility is the weighting of information. So they will get various sources of information from probation officers and mental health practitioners. And this can include a pre-sentence report that's completed by the probation officer, and sometimes will include in that report details of a person's forensic evaluation. In that pre-sentence report, if the individual is Indigenous, it will also include a Gladue report. Judges will also be there for pretrial conferences, weighting of victim impact statements, and making decisions on whether to sentence that young person as an adult. So if the young person has committed a particularly serious offense, then Crown Counsel may ask the judge to have the young person sentenced as an adult so that they would receive a lengthier sentence. And the Crown Counsel must demonstrate to the judge on the balance of probabilities that an adult sentence is necessary for protection of the public, one of the main goals of the YCJA. Okay, this one is very important. Presumptive offenses have been under a lot of scrutiny, maybe not as recently as 2021, but in the past 5 to 10 years, they've been very important. When the YCJA was first created back in 2003, written into the YCJA was this idea of presumptive offenses. So it was this presumption that if a youth was 14 or older and was found guilty of a serious and violent offense, and those offenses included homicide, aggravated sexual assault. So if a young person, 14 or older, was found guilty of one of those 4 offenses, there was what's called a reverse onus clause. This means that the burden of proof was placed on defense counsel to demonstrate why their young client would be better served and why the safety of the public would be better served by having that individual sentenced as a youth rather than as an adult. Basically, the onus was on defense counsel to show on the balance of probabilities why their client should not be sentenced as an adult. Another thing that maybe I haven't clarified yet, if a young person is sentenced as an adult, they don't actually get placed in adult custody. They serve their sentence in youth custody, and they can serve that sentence up until age 20. So here's how this works. Let's say an individual at 17 is sentenced as an adult to 3 years in custody. Once they turn age 18, they will be transferred to adult custody unless they can show why it would be more beneficial for them and why it would be more beneficial to their rehabilitation and the protection of the public by having that person remain in youth custody. Reasons often relate to the need to complete high school, or they've made connections to treatment providers in youth custody. In most cases, this application will be successful. So what I mean by that is the young person has turned age 18, but they will be successful in being allowed to remain in youth custody rather than be transferred to adult custody. The denial of such applications usually comes from instances where the now 18-year-old has a history of assaulting other more vulnerable kids in the custody center. So you've got 15, 16-year-olds who are smaller, less mature, and this 18-year-old is assaulting them or bullying them in some ways. That would be grounds for denying their request to remain in youth custody. So if their request is successful, they can remain in youth custody up until age 20. They still have to be on their best behavior. So it doesn't mean that they automatically get to stay up until age 20. The decision can be revoked like at any time if the individual is misbehaving. But once they hit age 20, there's no application to be made. They have to be transferred to adult custody. So for these adult sentences, these presumptive offenses that resulted in adult sentences, were eventually ruled by the Supreme Court of Canada to be unconstitutional because of the reverse onus requirement.